Hi everyone, very good evening to all of you and welcome to NLTI. My name is Mansi and I am going to be your guide and your mentor for this session. CLAT 2026 is just a few weeks away and I'm really sure that you're preparing really hard for the same and you must be nervous and excited. So, just to help you with your preparation a little better, we are here today doing this session for you to understand how last year legal reasoning was tested in CLAT 2025. So, in today's session, we are going to go through previous year questions of legal reasoning and we're going to understand how the questions were put, how can you solve these questions, and what should be your strategy while preparing for legal reasoning for the upcoming CLAT 2026. So without any further ado, I think we're very good to begin. So last year in legal reasoning, we had 6 passages and in total we had 32 questions. There were 2 passages which had 6 questions each and then there were 4 passages which had 5 questions each, right? So this means that there is no certain number of questions that is going to be dedicated to each passage. It can either be 5 or it can be 6. Also, one more thing that you should understand is that the number of questions dedicated to each passage otherwise in CLAT is also not certain. We've seen in the past few years that it keeps on changing, so it's dynamic. There can be 5 questions per passage also, there can be 6, there can be 10 as well. So be prepared. But what is really important to understand and observe in the questions is that most of the questions were actually asked directly from the passage. We'll understand it better once we'll go through all the passages, right? So let's just get started with the same and let's start with the first passage. So the first passage was about NCRB, and if you look at the length of the passage, it was not very lengthy, right? If you take some time out to read this passage, it would hardly take you 2 to 3 minutes to read this passage carefully. It has some stats mentioned in it. It has some information related to criminal justice system. But if you look at the bottom, this passage was about child rights in criminal justice system, right? So otherwise the information given is quite basic. Now, going to the questions that were asked from this passage, the first question is, which of the following issues children who are victims of violence during childhood face in life as per the author of the above passage? So clearly this is a question from the passage. Now if we look at the options, it says they may have difficulties in school, they may abuse drugs or alcohol, they may act aggressively and engage in criminal behaviors, or all of the above. Now if we go back to the passage, right, we will see that here from okay, from this line onwards, basically from the third line from the bottom till here, you'll see that there is the answer. They face difficulty in school, abuse drugs or alcohol, or act aggressively, suffer from depression. And these are the 3 options that we have anyway. So which means that the answer is all of the above, right? So clearly the answer was in the passage. So if you take some time out before jumping to the questions, if you take some time out to read the passage carefully, you could very easily answer this question. Now, the next question is, what is the primary objective of criminal justice system as mentioned in the passage? Rehabilitation, punishment, reformation, or protection of victims? Again, we'll go back to the passage and we'll see right here in the second paragraph, third line, the main objective of criminal justice system is deterrence, that is to punish. Right now, we go back to the options. Clearly, punishment of the offenders is the clear answer here, and the answer was right there in the passage. So again, if you read the passage carefully, you could have answered it very easily. Going back, coming to the third question, the National Crime Records Bureau, NCRB, is responsible for, and then there are 4 options. So if you know about NCRB, great. Otherwise, the name suggests National Crime Records Bureau. See, NCRB is one such organization in India which is responsible basically to collect all the data regarding crime that has happened in the country, right? So if you, this is not something which you will find otherwise in the passage. This is something which is of basic understanding, basic knowledge. So if you know about it, great. If you do not, but the answer to this is compiling and analyzing crime data. NCRB, please remember, NCRB is responsible for collecting and compiling all the data of all the crime that has happened in a country. And they publish an NCRB crime in India report every year, which tells us how much crime has happened in the country in the past 1 year. All right, moving ahead with the next question. Which category had the highest number of cases under crime against children according to NCRB report 2021? Now, the answer to this question is right there in the passage. I will first of all just quickly change the color so that we can highlight. All right, great. So now the question is the highest, the top category that was under crime that has happened with children, right? So right here is the answer in terms of percentage. Top categories were kidnapping and abduction. Right now, if we go back to the options and we look at the options, right, we have the option here, kidnapping and abduction, right? Clearly, the answer was in the passage. Next is which one of the following is the correct expansion of the term POXO used in the passage? Now, the term POXO has not been defined in the passage. However, it has been used multiple times in the passage, right? POXO is a legislation, it is an act which has been made to protect children from sexual offenses, right? Now, you might not know about it or you might know about it, totally depends on you. But otherwise, let's just assume that you do not know the answer to this question right now. If we look at the options, it says protection of children from sexual offenses, prosecution of criminals from sexual offenses, protection of children and women. Now, this entire passage was about child rights in criminal justice system. So if you've read the passage and if you understand the context, you will know that we're talking about child rights here. We're talking about children, right? So clearly the correct answer will be protection of children from sexual offenses, right? So like I mentioned, POXO is a legislation, it's an act which has been made to protect children from sexual offenses. It does not include women, okay? All right. Moving ahead with the last question, the sixth question of this passage, which is what risk do children face when exposed to the criminal justice system as per the passage? Now, the answer to this, again, if we go back to the passage, we'll see, all right, what risk do they face? Right. Here are the risks mentioned till this point. Right? So if you read this, it says that the risk of physical and psychological abuse, sexual assault, other harms, including inadequate educational opportunities and outdated vocational training. Now, if we go back to the options, limited access to vocational training, exposed to risk of physical abuse, mental health challenges. Basically, that entire sentence, right? Everything. So the answer is going to be all of the above. Now, if we just quickly observe this entire passage, there were 6 questions, out of which 4 were directly from the passage. 2 questions were of basic general information, general awareness, right? So even if you do not know those 2 answers, 4 answers you could very easily answer if you read the passage carefully. So what is the takeaway from this? That you have to first read the passage carefully, and after that you have to carefully read the questions and then answer. All right. It was fairly simple, fairly doable. Not a lot of legal information was required. Yes, basic understanding of NCRB on POXO. Right. If you know it, you could have answered it. Otherwise, 80% of the passage could have been easily done if you just read the passage carefully. All right, moving to the next passage, which talks about 42nd Amendment, which talks about environment protection, right? So it has not, it is taken from Supreme Court of India bolds right to life with climate justice. So Economic Times published this article, right? And it is an extract from that article. Now, if we look at the questions, it says in which, okay, first of all, we'll just quickly go through the passage. We'll just, have a quick glimpse of it, and we can see that there are hardly 3 paragraphs in this passage, which means, again, if you spend around 2 to 3 minutes to carefully read it, you can read and you can just take a gist of what all is happening under this. Now, if we go back to the questions, let's just take a quick look on the first question. It says, in which among the following changes were introduced for environment protection through the Constitution of India 42nd Amendment Act? Now, I'm not sure if you know about 42nd Amendment or not, but it is also known as the mini constitution of India. And several, multiple changes were done in the Constitution of India through 42nd Amendment, right? So it is anticipated that probably, I mean, honestly, all fundamental rights, fundamental duties, DPSPs, preamble, everything was slightly amended through the 42nd Amendment Act. But if you read the question carefully, it only talks about environmental protection. Now, if we go back to, okay, just a little struggle with the screen, never mind. Okay, if we just go back to the passage, we can see it mentions that the 42nd Amendment has introduced Article 48A and Article 51A Clause G. So if you know about these uh, provisions, you will know that Article 48A falls under the DPSPs, Directive Principles of State Policy, and Article 51A Clause G falls under fundamental duties. So when we are talking specifically about environment protection, only the DPSPs and the fundamental duties have been changed, and no change has been made in the fundamental rights, right? And this is something which we can take away from the passage itself, right? This is something which the comprehension is telling us. Now, if we go back to the options are fundamental rights, fundamental duties, DPSPs, and there is, you have to decide, right? You have to pick among these. So the correct answer is going to be 2 and 3, because like I mentioned, for environmental protection specifically, no changes have been made in fundamental rights. Now, moving ahead to the next question. The nature of binding commitment of India to reduce carbon emission through the signing of various international environmental conservation treaties, especially the Paris Agreement, may be described as, and then there are 4 options. Now, before we dive deep into this, I just want you to understand a few things. Whenever India, as member of UN, right, they sign any convention, any treaty, and it becomes signatory to any international convention or treaty, it has to make laws in it. In basically, we have to make changes in the domestic laws to follow and to basically you basically have to obey those conventions and treaties, right? And to obey those conventions and treaties, you have to make changes in your domestic law as well. That's the rule. Now the question here is that since India is now part of Paris Agreement and several other international conventions which is prescribing to reduce carbon emission, right? So now what India has to do, first of all, like I've already mentioned, the logic says that India has to follow it. Why? Because it's part of that treaty now. It has signed on that treaty, right? Now, to if we do not understand that international law rule, that's also fine. The same answer is also here in the convention. Sorry, in the passage. It is saying that India is signatory of various international environmental conservation treaties during which India has the binding commitment to reduce carbon emission. Okay. Now, this is something which is there in the passage itself. Now, if we go back to the question and we look at the options look quite similar. Okay. They are quite identical. The first option is the signatory shall take adequate measures to reduce carbon emission. Second is the signatory may take adequate measures to reduce carbon emission. Third is the signatory should explore the possibility. Fourth is the signatory may formulate necessary policies. Now, there is a word binding commitment that has been used, which means that India is bound to make laws to ensure that there is reduction in carbon emission. It's not a choice, it's a mandate, right? And whenever there is a mandate, the word shall is used. If you use the word may, right, it's an option, it's a choice. You may do it or may not do it. But when the word shall is used, it means you're bound to do it, it's a mandate, and you definitely have to do it. So the correct answer will be option A, that the signatory shall take adequate measures. They may seem identical, right? But just one word can change the entire meaning and can change the entire interpretation, and that is something you have to be very careful about. Otherwise it might seem really simple, but just one word can, change the entire meaning. So shall take adequate measure is going to be the right answer. Now, moving ahead with the third question. Under Article 51A, Clause G of the Indian Constitution, it is specifically mentioned that citizens shall have the duty to protect and improve the natural environment. That includes, now, if you have read fundamental duties, great. Now, even if you have not, one thing that I would always suggest to not just law aspirants, to every citizen of the country, that you should at least read for once in your life the preamble of the Constitution, fundamental rights, and your directive policies and fundamental duties, at least, right? Just so that you know the basics of your Constitution. If you know about it, great. If you've read it, great. If you do not, right, the answer to this you can easily find in the passage also. Otherwise, they have used the word natural environment, right, which only includes rivers and lakes and forest and wildlife. All living creatures are not part of natural environment, right? So it's the answer to this is option D, which is only A and B. Okay, moving ahead with the next question. As per the aforementioned passage and decisions of the Supreme Court, the fundamental duty to preserve and protect natural resource is upon the state only. Citizens alone have the fundamental duty to preserve and protect natural resources. Both state and citizen have the duty, or it's state's duty to maintain ecological balance and citizens' right against climate change. Now, the answer to this question is in the passage. If you read the passage carefully, without any issue, you can answer it. Now, we'll just quickly go to the passage. Here, there is this line. In many judgments, the Supreme Court ruled that both state and resident have a fundamental duty to preserve and protect their natural resources. Right now, if we go back to the, yeah, right? So both state and citizen have the duty. This is something which we're taking away from the passage, right? So fairly easy to answer. Next question is, according to the passage, what makes India committed to reduce carbon emission? Now, this is something very similar to the previous question, not the previous question, but the 61st question that we did, right? 60th question, right? What makes India binding? What makes India binding? The international conventions, basically, right? This is something which we have already discussed. So, because of being a signatory to international environmental conservation treaties, that's why India is committed. That's why India is bound to follow all. They are bound to make laws to reduce carbon emission, right? This is also there in the passage. This is also similar to one of the questions that we have already done. And yes, the answer is pretty direct in this quiz. And the next question is, the passage mentions that any disturbance with these basic elements would amount to violation of Article 21. Article 21 deals with what? Now, again, like I've already mentioned, you should definitely know about your fundamental rights, your fundamental duties. You could very easily answer this question if you have read your fundamental rights. And if you're preparing for CLAT, fundamental rights is one such topic which you definitely cannot ignore, right? And fundamental rights, every right, right from Article 20, Article 12 till Article 35, you should have it on tips which article means what. Now, Article 21 means right to life and personal liberty. I'm sure a lot of you would know it, right? If you do not, then I repeat, Article 12 to Article 35. You should know which article provides what, right? Part 3 of the Indian Constitution talks about fundamental rights, which has Article 12 to 35. You should know about each and every article in that case, because it's important. You can see there is a direct question just about the article, so that can be tested again. So definitely you should be aware of the same. Now, these were the 6 questions which were from the constitutional law. Right now, moving ahead with the third passage, which is from contract law. Contract law is one such area which almost always I see this being tested in CLAT. So again, be very careful and be well prepared with this subject, right? In this passage, if we just quickly go through it, right, we'll see that a lot of discussion is happening again around void agreements, right? Void agreements, voidable contract, and valid contract also. One of the most important topic from contract law, and not just for CLAT, any sort of law entrance exam I've seen in my life. This is, I believe, this is one of the most important topics. Now, this is again is being tested here, right? Okay. All right. Now, moving ahead with this, let's see what is the first question. It says, which of the following best describes a void agreement? Now, if we go back to the passage and just try to read it carefully, right? It says void agreements are fundamentally invalid, making them unenforceable by default. These agreements cannot be fulfilled as they consist of illegal elements and they cannot be enforced even after subjecting it to both the parties. So basically, it means void agreements are those agreements which have no legal validity, right? No matter what, no matter how well you've planned this, these are the agreements which are not enforceable in law, which has no legal validity, right? So now, if we go to the question, which is which of the following best describes a void agreement? We have four options. We've understood that void agreements are those which do not have any legal validity. Now, let's read the options. An agreement that is valid until declared invalid, an agreement that has no legal effect from the beginning, an agreement that is legally enforceable, and an agreement that can be enforced if one party chooses to do so. Right? So, like we have already discussed, like it has been expressly mentioned in the passage also, that the agreement has no legal effect, basically, which has no legal validity, that is a void contract. Next question that we have is, a contract between two parties to rob a bank and share the proceeds equally can be termed as four options: void contract, valid contract, voidable contract, and legally enforceable contract. Now we'll go back to the passage to answer this question. We read here that void agreements are fundamentally invalid, right? These agreements cannot be fulfilled as they consist of illegal elements. Now, what does that mean? Illegal elements basically means that the purpose behind doing this agreement is something which is against law, right? Which is something which is illegal. So, you cannot basically carry that agreement out. So, if the purpose, if the objective behind um, an agreement is illegal, then it's a void contract. Now, if we read the question carefully, it says contract between two parties to rob a bank, right? So, robbery is a crime that has been recognized under the Indian Penal Code, now the BNS, right? So, robbery is a crime, which basically means the purpose, the objective behind the agreement is illegal. So, it's a void contract. All right. Moving ahead with the next question. An agreement made by an adult but involving a minor child, right? Here, please, where the signatory is a minor child himself, this agreement would be what? Now, this is not something which has been expressly mentioned in the passage. However, one very important factor about void contracts are also that if any minor is entering into a contract, that contract is void ab initio. Void ab initio basically means it's void right from the beginning. So whenever you see the term minor child anywhere in contract law, please make sure that you know that the agreement is going to be void all the time. All right, so it's going to be a void agreement. Why? Because a minor is entering into a contract. It's not there expressly in the passage, but it is one of the conditions for the void contracts, right? So, moving ahead with the next question, which of the following scenarios would most likely result in a void agreement? Now, see, a lot of discussion is happening around void agreements. I repeat, void agreements are those agreements which do not have any legal validity, which do not exist in the eyes of law, right? And which cannot be enforced in court. Now, which of the following can be a void agreement? First is an agreement signed by someone under duress. Duress basically means threat or coercion. Someone has forced you or threatened you to enter into a contract. That's called duress, right? Second is a contract with mutually agreed terms to sell a house, an agreement to pay 10 lakhs on getting a government job, and last is a contract with minor who understand the terms. So first situation might seem like a void contract, but to your surprise, it's not a void contract. It's called a voidable contract. Now, what is a voidable contract? where a contract has the ability to become void. It's voidable, right? So basically, voidable contracts are valid contracts till the time one of the parties they decide to make it void. How is that possible? Now, if let's say some person has entered into a contract under duress, under threat, right? A person threatened B person to enter into a contract, and now B person has entered into a contract. Now, later on, if B person wants to cancel and make that contract void, he can do it. Till the time he does not make it a void contract, it's going to be a valid contract only. So this makes this contract a voidable contract and not a void contract. It's voidable. It can become void if one party decides to do so. Second contract is where both the parties have mutually decided to sell a house, right? So they've mutually agreed to some terms. It's a valid contract. A person offered something to B, B accepted it, they're okay with it, it's a valid contract. Now, this one question basically was um, objected last year, right? Why? Because it has two such options, and both these options are actually void contracts. First one, the third option basically says an agreement to pay 10 lakhs on getting a government job. It's basically bribery, right? If you're bribing government officials to get you a government job, it's bribery. Bribery is a crime, right? So which means the objective is illegal. So it is a void contract. Second is contract with minor. Like we've already discussed, right? Anything contractual a minor does, it makes the contract void. It has no legal validity, right? So it doesn't matter, even if he's understanding the terms, it doesn't matter. It still is going to be a void contract. So both these are basically void contracts. So this basically question was objected, and grace marks were given to the aspirants last year, to the candidates last year for this question. But both these contracts basically are void. Now, moving ahead to the next question, an agreement made without consideration is generally a void agreement only. Again, this is not something which is written in the passage, but one very important thing about void agreements is also that if there is any agreement done without consideration, it's a void agreement. Now, what is consideration here? Consideration is anything that you take in a return of giving some. Basically, let's say A and B are entering into a contract that A is going to sell his house to B. Right now, A sells his house to B, and B is going to pay, let's say, 50 lakh rupees to A. Now, in that case, 50 lakhs is going to be the consideration. So, in contract, whenever you are um, giving something to someone, in return you also expect something, right? That is called consideration. And contract law says that doing any agreement without consideration is going to be a void contract, but there are a few exceptions to the same, which has been discussed under section 25 of the Indian Contract Act, right? So there are a few exceptions. For example, if if there is any gift being given to you, that's going to be a valid contract in that case. But otherwise, any contract which is made without consideration is going to be a void contract right from the beginning. Okay? All right. And yes, these were your questions from the contract law. The next question, the next passage that we have is from GI, from geographical indications, which is basically from intellectual property laws, right? So it's a fairly small paragraph. If you have a take, just look at it. It's not going to take you more than 2 minutes to read it. I'll just quickly read it for you so that you are all with me in this. So the passage basically says that geographical indications are a form of intellectual property that designates a product as originating from a specific geographical location, where a given quality, reputation, or other characteristic is essentially attributable to its geographic origin. GIs protect names that are used to identify products with specific qualities or characteristics due to their geographic origin. For example, champagne refers to sparkling wine produced in the Champagne region of France, and Darjeeling tea refers to tea grown in the Darjeeling region of India. The protection of GIs ensure that only products genuinely originating from a specific region are allowed to use the geographical name. This helps maintain the product's reputation and quality. prevents misuse or imitation, and supports local economies by promoting regional products. International agreements such as TRIPS agreement under the World Trade Organization provide a framework for the protection of GIs globally. Now, GIs or geographical indications are basically part of intellectual property rights, right? We have a few recognized form of intellectual property. We have copyrights, trademarks, designs, patents. GI, geographical indications, are also one type of intellectual property. This entire passage is just about geographical indication as an intellectual property, and then there are associated questions regarding the same. And now let's just quickly look at the questions. Which of the following statements about geographical indications is not true? We've read the passage now, all right? We've read the passage, so it should be fairly easy for us to understand and attempt this question. Now, let's just quickly look at it. It says GIs are protected under international law to ensure that only products from specific regions can use the GI name. Second is the use of a GI name can be legally challenged if it is used by products not originating from the specified region. Third is geographical indications can be used to any product which is licensed regardless of its place of origin. And fourth is that the TRIPS agreement under the WTO establishes a framework for protection of GI. Now, if you look at the question carefully, a word not has been used. So basically, one of the statement is wrong. Now, first was talking that GI are protected under international law. It has been protected, right? The use of GI can be legally challenged if it is used by products not originating. It can be, right? GI can be used to any product which is licensed regardless of its place of origin. Now, this is something which is not allowed, which is basically called misuse of GI. Now, if a specific product is not being originated from a specific geographical location, but it is being named after that geographical location, is violation or misuse of GI. So that's not something which is recognized or which is true about GI. About the TRIPS agreement, we've read in the passage already, right? TRIPS agreement talks about GI. So if we go to the next question, if a product named Darjeeling tea is produced outside of the Darjeeling region, which of the following legal action is likely to be taken? So what is important to note here, that outside of Darjeeling, right? So product is being produced, right, but outside the region, outside the geographical area. Now what can be done? The product can still be sold with a disclaimer. And what is the legal action that can be taken? Okay, first is product can still be sold. Second is the use of GI can be legally contested and potentially prohibited, right? Third is the product can be sold under different GI name, like not Darjeeling tea. Or last is the product can be marketed as Darjeeling tea and will face no legal consequences. So some legal action is something which is important to note here, right? In first and third case, we are not taking any legal action, right? There's just nothing legal happening. Even in the fourth one, there's nothing legal happening. However, using a product on name of a geographical area, but it is not originating from that geographical area, is misuse of GI, which is basically violation of intellectual property rights. And in that case, it can be legally contested, yes, and it can also be potentially prohibited, yes. So the answer is going to be B. All right, now moving ahead. The next question is, which of the following is not a potential consequence of misuse of GI? What can what cannot happen basically is not a potential consequence. Loss of consumer trust will happen, right? If you will misuse a GI. Decrease in the market value of the GI protected product, that is also going to happen. Compulsory license on the patents of misusing the entity, right? That might not happen, right? And fourth is potential legal action, right? Of course. So the consumer will also lose trust if you will, if you'll market a product which is not originating from a specific area, but by marketing it in a way that it is originating from a specific area, the consumer will lose trust in your product, right? The market value of the original product will definitely be affected, and a legal action can also be taken against you if you're doing so. So what can not be done, what might not happen, is compulsory licensing. So what is not a potential consequence, that is compulsory licensing of the patent. All right, so fairly easy. You might not find all these answers in the passage, but the passage was there for you to understand what GI really means. So that once you've understood the concept, you can apply that principle, right? And you can apply that logic and answer the questions. Now, the next question is, in the context of GI, which of the following scenarios best illustrates the concept of geographic origin? Okay, a product's name is changed to reflect its local ingredients rather than its place of production. A product is marketed with a GI name, even though it is produced in a different region. A product is identified by a GI name that corresponds to the region where it is traditionally made with distinctive qualities. And a product is sold under a generic name. Okay, now, if you read the question carefully, it says, in the context of GI, which of the following best illustrates the concept? So basically, which among these is actually a true example of a good example of GI? First is, product is being a product name is changed to reflect its local ingredients. Now, see, GI is not about local ingredients. It's about originating from a specific geographical area. Local ingredients basically has nothing to do with it. It's much more about the geographical area, right? So this one doesn't hold good. Second one is, product is marketed with a GI name, but it is produced in a different region. So this is basically misuse of GI. Third is that it is identified by a GI name, right? That corresponds to a region, and it is traditionally made in that region also, and it has distinctive qualities due to that location, which is basically exactly what GI really means. And the product is sold under a generic name. So, I mean, this one also is not a good illustration of GI. So, geographical indication is going to be that product which is originating from a specific region. It is traditionally made or cultivated there. It has distinctive qualities due to that location, right? Otherwise, all these three do not hold good. Local ingredients, I repeat, local ingredients has nothing to do with GI. GI is much more about that location and that specific area, that specific place. Ingredients is not something which decides GI. Okay. Now, the fourth and the last question basically from this passage is, choose the most appropriate objective of the TRIPS agreement concerning geographical indication. Now, for those who do not know about TRIPS agreement, it's one international agreement which basically says it's about intellectual properties, trade related aspects of intellectual property rights. This is the full form of TRIPS, right? So all the laws, all the rules that has to be followed globally regarding intellectual property rights have been given under TRIPS, right? So it's not just applicable to GI, it's applicable to all forms of intellectual property rights: copyright, trademark, patent, design, GI, everything. Okay. Now, what are these options we have that we have here? To harmonize intellectual property laws across member countries, to ensure uniform product labeling, to provide framework for the protection and enforcement of GI, and to promote international trade. Now, the answer to this is something which you will find here also. So we'll just go to this passage and we'll see international agreements such as TRIPS under the WTO provide framework for the protection of GI globally. This is the answer. It's right there in the passage. Only one question in this entire passage was directly uh, from the passage. Otherwise, all the questions were much more analytical in nature. It You had to basically understand the concept of GI from the passage, and then you had to apply those principles, and you had to analyze the situation, and then you had to answer it. So much more analytical questions, and only one question from the passage. And the next passage that we have is from the Public Examination Prevention of Unfair Means Act. Right now, if we just quickly look at this passage, it's a decent length passage. We'll take a minute and read it carefully so that we can answer the questions later. Okay, so the passage says that the Public Examinations Prevention of Unfair Means Act 2024, that has provision for up to 5 years imprisonment and a fine of up to 1 crore of malpractices and organized cheating in government recruitment exam, was notified by the union government and came into effect from June 21, 2024. The bill had received assent from the President of India on 13th February. The, the Act mentions punishments for leakage of question papers or answer key, all right, directly or indirectly assisting the candidate in any manner unauthorized in the public examination, tampering with the computer network or a computer resource or a computer system, and it has been defined as offenses done by a person, group of person, or institutions. Besides these, creation of fake websites to cheat or to monetary gain, conduct of fake examinations, issuance of fake admit cards or offer letters to cheat or for monetary gain, and manipulation in sitting arrangements, allocation of dates are also among the offences punishable under the law. Any person resorting to unfair means and offences under this Act shall be punished with imprisonment for a term not less than 3 years, but which may extend to 5 years and with fine up to 10 lakh. A service provider engaged by the public examination for conducting the examination shall also be liable to be punished with imposition of fine up to 1 crore, and proportionate cost of examination shall also be recovered from it. Such service provider shall also be barred from being assigned with any responsibility for conducting the exam for 4 years. Okay, now this is what the passage had to say, right? This is about punishing organized crimes when it comes to government recruitment exams. All right. Now, if we look at the questions, the first question is fairly simple, fairly direct. A bill becomes an act only when. All right, it is not directly from the passage, but it is something which is common understanding. When does when does a bill become law? Right. So a bill becomes an act when it is passed by it is given assent by the president. So if you know, I mean, this is basic SST, I believe, right? If you know this thing, how laws are made in the country. So if a law has to be made, first of all, it has to be passed by both the houses. Once it's passed by both the houses, Lok Sabha and Rajya Sabha, it goes to the president. And once the president gives assent to that bill, then it becomes an act, right? So the answer to this is going to be this one. Um, there is a slight, a very brief discussion regarding the same that has happened here, not even just a very brief mention of the same is here, that the bill had received assent from the president on February so and so. So it basically means that the bill became an act after getting assent from the president on 13th February 2024, right? So a bill becomes an act once it has assent from the president. Second question from this passage is that a service provider engaged by public examination authority for conduct of examination indirectly helped his family member by giving hint on questions that were supposed to be asked. Now, what should be the punishment given to him? Now, in this case, the punishment is also already mentioned here in the passage. Let's go. All right. Okay. Yeah. So it basically says that there is imprisonment up to 5 years and fine up to 1 crore, right, for any sort of malpractices. So if we go back to the question now, right, so he can be punished with imposition of fine up to 1 crore, right? So this is something which we are taking away from the passage itself. Now, the next question is that an invigilator of a public examination is found guilty of manipulating the sitting arrangement to favor his relative, right? Which among the following is the appropriate punishment as per the punishment mentioned? Now, this is something also which we have already seen here in the last paragraph, right? If any person is caught doing any such thing, right, they can get an imprisonment not less than 3 years. So it's going to be either 3 or more than 3, and fine up to 10 lakh. It cannot go beyond 10 lakh. So the punishment can be 3 plus, and the fine has to be up to 10. All right, can be less than 10 also. Okay, 3 to which may extend to 5 years. So the punishment is going to be minimum 3 years, maximum 5 years, and the fine is going to be maximum 10 lakhs. So now if we go back to the options and we see what can be the answer here. So it can be imprisonment 4 years, right? Like we just saw. Imprisonment can be 3 to 5 years, all right? Minimum 3 and maximum 5. And fine can be up to 10 lakhs. So this is 5 lakhs here. So the option D is going to be the correct answer. So it's just how you apply it, right? You just have to read the passage carefully and you have to apply the legal principle, and it's as simple as that. Okay. Now, the next question. Identify which of the following is not an unfair mean relating to conduct of a public examination. Okay, which is not considered as an unfair mean. First is coaching center conducting mock tests. Second, coaching center offering help to its students during the examination. Third is center superintendent of the public examination provides sitting arrangement of all its students of a coaching center in one specific hall. And last is the center superintendent of the public examination assisting the candidate. So clearly, if the coaching center is conducting any sort of mock test, that's not unfair. That's part of preparation. So the correct answer is going to be A. Otherwise, all these three activities are actually unfair means relating to conduct of a public examination. All right. The next question that we have is, who among the following is not a service provider in context of a public examination? Now, service provider is basically a person or an organization or a body which is assisting in conduct of that exam, right? So, who among the following is not a service provider? Coaching center, which prepares students for passing in the exam. Printing press, where the question papers are printed, right? Software company that is managing the website of the public examination, or the company which scans the OMR sheet. So all these three are basically directly related to the examination, right? The printing of question paper, software company that's managing the website, and where the OMRs are being scanned, directly related to the examination. While the coaching center, which is just giving coaching to the students for preparing for their exam, is not a service provider in that case. Okay, fairly direct, fairly simple, basic common sense, right? I don't think it's very difficult. So this entire passage, all these 5 questions, hardly one question was there which the answer to which was there in the passage. Otherwise, all the other questions were either common sense based or purely analytical in nature. So, but still, I still believe that anyone who just reads the passage carefully can answer the questions, 80% of the questions correctly in this entire passage. Okay, now the last passage that is there is about right to privacy and data protection, right? This one is fairly important, and we'll just have a quick read of this passage also, so that we do not, so that we can answer the questions better. Okay. So the passage says that the Supreme Court of India declared that the right to privacy is a fundamental right and the right to informational privacy is part of this right. Subsequently, the Parliament of India enacted a new law relating to digital personal data protection. The law applies to Indian residents and businesses collecting the data of Indian residents. It also applies to non-citizens living in India whose data processing is in connection with any activity related to the offering of goods or services that happens outside India. The law allows personal data to be processed for any lawful purpose. If the personal data is sensitive, then additional safeguards are to be observed. The entity processing data can do so either by taking the concerned individual's consent or for legitimate uses, which include situations where an individual has voluntarily provided personal data for specific purpose. The law requires that an individual's consent must be free, specific, informed, unconditional, and unambiguous with a clear affirmative action and for a specific purpose. The data collected has to be limited to that necessary for specified purposes, and a clear notice containing these details has to be provided to consumers. Individuals have the right to withdraw consent if consent is the ground on which data is being processed. The law also creates rights and obligations for individuals, right? Individuals also have the right to correction, completion, updating, and erasure of their data. Besides, they have a right to obtain redressal for their grievances and a right to nominate person who will receive their data. All right. I think fairly understandable passage regarding India's new data protection law and what all different things have been covered under the same. Now, if we go to the questions and let's see what sort of questions are being asked from this passage. So, first question is that an Indian company collects personal data from its users to provide personalized services. The company intends to share this data with a third party, all right, for targeted advertisement. Under the digital personal data protection law in India, which must the company do? What must the company do before sharing the data? All right. So if we go back to the passage, what the company definitely has to do is to take consent. This is something we just read, right? That the entity processing data can do so by taking concerned individuals' consent for legitimate use. Okay, now if we go back to the options, it says obtaining explicit consent from the users, share the data by informing the users, or encrypt the data and share it with the third party vendor, or just inform the third party vendor that the data is sensitive. So basically the answer is going to be taking consent, explicit consent from the users, something which we can directly take away from the passage. Okay, all right. Second is the second question is that a social media platform processes user data based on the consent given during account creation, and a user now wishes to withdraw consent to process their data under the digital personal data protection law in India. Which what must the platform do? Now if the consent has to be withdrawn by the user, then what has to be done? Refuse to accept the withdrawal request. Second is comply with the legal requirements and stop processing the data. Third is continue processing the data but notify the user. Or fourth is allow withdrawal only after 30 days. Now, if we go back to the passage, right, it says that the individuals have the right to withdraw consent. The platform cannot take it away from them. They have the right to withdraw consent. And if the user wants to withdraw their consent, then the company has to comply. It has to obey, has to basically comply with the legal requirements, and it has to stop processing the data. All right, the next question is a financial institution collects biometric data from its clients for verification purposes. If the client wish to know what data has been collected under the digital personal data protection law, what right allows them to request this information? Now, this is not something which you will find directly in the passage, but the passage definitely talks about the fact that if the user wants to know how is their data being used or what data has been collected, they basically have right to know, right? So that's also part of right to access. They have access to all the information that has been retrieved, right, about them and how that information will be used. They have access to that information. So the correct answer to this is going to be right to access. Okay. The fourth question is a startup provides a health tracking app that collects sensitive health data from users under the digital personal data protection law. What additional precautions must be taken by the startup? First option is no additional measures. Second is ensuring explicit consent and adopting higher security standards. Third is storing the data only with the government agencies. Fourth is storing the data only with the hospitals and other healthcare institutions. Now, again, if we go back to the passage, it directly talks about this, that if any sensitive information has to be taken, right, in that case, what has to be done? So basically, it is there mentioned in the passage itself that if any sort of sensitive information is being taken up, If the personal data is sensitive, then additional safeguards are to be observed, right? So this is something which is given in the passage itself. So if we go back to the question now, it says that explicit consent and higher security standards. Additional measures have to be taken, definitely, right? And the fourth question is, as per the passage, what are the rights included under the Digital Data Protection Law of India? Right to get summary of collected data, right to know whom the data has been shared, right to correct and update, right to get the data removed, right to decide who can receive the data, right to get redressal. Now we've read the passage, and all these things, all these rights have been recognized under the digital protection law, right? Data protection law. So basically, the answer is going to be D, 1, 2, 3, 4, 5, and 6, right? So this was your legal reasoning part that was there in last year's question paper. I hope you found it useful. What is the takeaway from these entire question is that a lot of questions are directly being tested from the passage. So take a lot of time to read the passages carefully and then jump to the questions, because a lot of it, around 70 to 80% of questions were directly from the passage. So if you understand what the passage is saying, what is the context, what is basically the entire reasoning behind it, you can very easily answer 70 to 80% of the questions. Some questions will also test your basic understanding about some legal principles, right? For the same, please make sure that you know about at least the fundamentals of law, like your fundamental rights and your fundamental duties, DPSPs. When it comes to law of torts, the specific torts that we have for contract law, offer, acceptance, void, voidable contracts, all these different topics, which basically forms the basics of law. That is something which you definitely should know, because a lot of it was also tested. Otherwise, just being able to read carefully and apply those, understanding those principles carefully in those questions will also help you a lot, and will help you to answer the questions carefully, right? So this is something which I had to share with you. If you have any questions, please feel free to drop your questions. I'll be more than happy to answer. If no, then we're good to I'll just quickly check if we have any questions. Hmm. Okay. I cannot see any direct questions. But all right, if there are no questions, guys, then thank you so much for joining. I hope you found it useful, and we'll meet again very soon. And have a great evening ahead. Thank you, everyone. Bye bye.